Good evening, and welcome again to Public Perspective. I'm your host, Kevin McDermott. And election time is around the corner, so if you remember from the last time you voted, there's a whole list of judges at the bottom of your ballot. Most voters pay very little attention to it, but it's one of the most important positions you can vote for. So our guest tonight is William Bill Wojcik, and Mr. Wojcik, you are running for circuit court, countywide.
Yes, Kevin, I'm running for a full circuit court judicial vacancy from the position that was previously occupied by Susan Russetti-Grussel.
And she has retired, right?
She retired a couple of years ago. An appointment was made to fill her position up until this election. So this election will decide who sits in her prior seat for the next 6 years.
So explain, many of you have no idea what the difference is between countywide circuit court and the sub-circuits.
Sure. Well, the sub-circuits have to do with a particular geographical area. Countywide means just what it says. A full circuit position means that a full circuit court judge has all the powers of any judge, the highest powers in Cook County. Associate judges, for instance, have lesser powers, can't hear certain types of felony cases or cases that may result in incarceration of greater than 1 year. And the sub-circuit elections usually are fought out in somewhat the same manner as state representative races. So they're very much more local. And of course, there's 5.2 million people in Cook County, so we have a major task in getting out to all the people in the county and letting them know that we are candidates. But Kevin, you're 100% correct. Most people go into the voting booth and they see a name they like, or if they prefer a man as opposed to a woman, or woman as opposed to a man, that's generally how they vote. And it's really not the right way to do it. If a person can, they should make an effort to try and find out whatever they can about the judicial candidates.
And there are resources online, right? We were talking before the show about a couple of things online that people can use to find which judges have been rated as qualified by the various bar associations, which you have been qualified by all of them, right?
I have been, and there are a number of ways to get that information. Certainly you can go to the State Board of Elections website and get leads from there, but through the Chicago Bar Association, Chicago Council of Lawyers, the Illinois State Bar Association, and many, in fact most major newspapers publish those kinds of lists. There's so many bar associations now, Kevin, that you do need a scorecard to keep track of them. But for the most part, there are 12 bar associations, of which there's a handful that are the old line, kind of mainstream bar associations, such as the Chicago Bar Association.
So as you're running countywide, you mentioned this earlier, it's very hard to do any kind of campaign countywide because, as you say, more than 5 million people, and I think it's over about 200 different communities within Cook County. So how do you do that as a judge? You know, we think of judges being kind of above the fray of campaigns, and yet still you have to do it because you have to get your name out. So how do you balance those out? How do you run a judicial campaign without looking like a politician?
Kevin, if I knew a really good answer to that, I would become a political consultant instead of a candidate for judge. But truthfully, it's a very daunting task. Of those 5.2 million people in Cook County, 3.7 are over the age of 18. And now with the registration window being what it is, many of those who have not previously registered can be registered, although the deadline for registration in this election has just passed. But there's so many people in such a wide geographical area. The question is, as you say, what can you do? So what we try to do is post our judicial philosophy. And you can find that on the State Board of Elections website. A candidate may, but does not have to, post a statement about himself. There are outlets such as the Chicago Tribune, other major newspapers that allow candidates to post, in essence, a biography or a resume.
And also the Cook County Clerk's website as well.
The Cook County Clerk's website, absolutely. And if a person wants to find this information, they can find it. But it's not going to be front page news, so they do have to ferret it out.
In fact, the only front page news we ever get about judges are the ones who've gotten themselves into trouble. So
Of
we don't want that.
Of course, yeah.
So
And
let's
that's
talk-
unfortunate. That's unfortunate.
But judges, like anyone else, sometimes they go astray. You know, judges are humans. And as you mentioned, people doing their research, it seems to me very important that people do a little background looking on judges because, as we say, judges are people, and some of them aren't always doing the things that we as voters would like them to do. So it is important for voters to look in and see, to learn what they can about the judge candidates and make informed decisions. So let's talk a little bit about your background and what brings you to this, because you've been in private practice for many years, and now you're deciding that it's time to take the next step and be on the bench.
That's right, Kevin. I have been in private practice for 35 plus years, 36 come May 1st of this year, and all of those years have been spent in private practice. So I believe I have a unique perspective that would benefit the bench and the bar as well as the public at large. And that's the philosophy of someone who has dealt with people at a grassroots level, face to face, for over 35 years. So my background is different from most judicial candidates in that most come from a background of having been with the state's attorney's office, having been with the public defender's office, or corporation counsel's office, attorney general's office, some type of governmental background. And then even if they go out into private practice for a year or two, it's usually not long before they seek either an appointment or an elective position on the bench.
So what about the private practice gives you the qualification that you think that these other people may lack?
Sure. I've been concentrated in personal injury and medical negligence, as well as workers' compensation, for almost my entire career. Many of our cases have resulted in million and multi-million-dollar verdicts and settlements. But I think what's really unique is for a sole practitioner to be involved in handling major cases, complex cases, unique cases in many instances. That's somewhat unusual and gives me a somewhat unique perspective and a perspective that's not widely represented on the bench at the present time.
So what would be an example of that, like a complex case, something that was very difficult to figure out? And why would, talk about the complexity and how that might be relevant to people generally, or how you could broaden that into a more generalized perspective on the bench?
Yeah, that's a great question. I represented in the mid-90s, Kevin, 110 women of 122 women plaintiffs in a case that they brought against their gynecologist, his medical group, a major hospital on the south side, as well as a national laboratory. And the case was brought because the doctor for all of these women was performing unnecessary gynecologic surgeries. Of course, it took a long time for this doctor to be found out. And his methodology was pretty sinister if you consider that as a woman would come into his office and he would do a normal gynecologic exam, he would tell these women that they were in danger of contracting cervical cancer because they had what he termed polyps. And he said he would remove them and basically protect them as a good doctor and monitor them and keep them from contracting cervical cancer. Well,
You can imagine that the reaction would generally be, sure, sign me up.
Sure, and it was very hard for these women because some of the women, some of the patients of this doctor were in their 20s, and they're being told suddenly they're at risk for cancer. And you know what that word cancer does
I do.
to a woman, a man, or a family. We had women who were in their mid-20s going home and writing their wills because when they would come for subsequent visits, the second, third, fourth time they would be examined, this doctor would tell them that they had more polyps, and then 3 months later, more polyps and more polyps.
Now, he was making this up? This was not, in fact, true?
Well, it was not, in fact, true, but what he would do is take, or at least he would tell the women that he was taking a sample of their tissue and sending it to a laboratory for analysis. And then when the pathology specimen would come back, as either benign or in some cases unidentifiable, then he would tell them the coast is clear, we've done our job. I've by doing these procedures prevented you from contracting cancer. And what is so sinister about this, Kevin, is this doctor would do these procedures by and large in his office, occasionally in the hospital, but by and large in his office. And
so unsupervised by any other authority here.
Right, so there's no supervision, although we believe some of his medical group may very well have known what he was doing, or at least, were acquiescent in allowing him to continue in this practice. But he would tell these women that he would take whatever the insurance companies would pay him for these procedures because it was so important that they have them done. So a woman could get a bill for $1,500 if insurance paid, let's say, $300. He would take this bill and just rip it up in front of them and say, I'm not worried about the other $1,200. I will take the $300 because these procedures are a must for you. So he not only was performing the surgeries unnecessarily, but he was making the women think he was Marcus Welby in the meantime. So it was a very difficult case, as any medical negligence case is. But we had to fight some of the biggest firms in Cook County.
Now, was it
on the defense side?
Did it appear that he was strictly doing this for the money? Was that what your interpretation was?
We concluded ultimately that yes, he was doing it for the money. Certain facts came out during the course of discovery that indicated he had an addiction, or at least a strong affinity to using prescription drugs, and that was part of the madness.
Yeah.
Women would get calls sometimes at 4 o'clock in the morning with, the message, this is Dr., and I won't mention his name, but it is public record, and he would tell them what the results were of their pathology. And of course they would think this is, very odd. When they would relate these stories to me, I certainly thought it was very odd and suspected that there may be some kind of backstory involving drugs or something along those lines, and it did turn out to be true.
So in this case, you went up against some of the insurance companies, I would imagine, or certainly the powerful law firms that his medical practice was able to bring. Is that where you were going a moment ago before I interrupted you?
Yes, no, that's absolutely correct. So it was the kind of case that, for lawyers, you might say that when the case was called, half the courtroom got up and approached the bench because there were so many lawyers involved. On the plaintiff's side, I represented 110, as I mentioned, but there were half a dozen other lawyers, very good lawyers, who represented one or more of the other 12. And the defense side was populated with some truly excellent lawyers, lawyers among the best, in my view, in Cook County or in Chicago or anywhere in the United States. So we had our work cut out for us. We were outmanned in the sense of My firm consisted of myself and my secretary. Most of these firms consisted of, 100, 150, 200 or more partners and associates. Clearly, finance-wise, they were infinitely more well-financed than we could ever be. And we prevailed. And it's really a tribute to the bravery of these women, because they were attacked in many ways, asked a lot of questions about their personal life, their sexual history, some really, really personal things. We were fortunate in being able to get a lot of those questions suppressed or quashed, but they were still allowed on the defense side to ask a pretty fair number of highly personal questions. So some women did not want to do that. Those that didn't, either did not remain in the case or didn't go forward. Certainly understandable. But the bravery of these women is really a testament to them.
Now, this was a civil case, right? So this was you were going for a judgment, an award, correct?
This was a civil case,
and
yes.
Was there any consequence to the doctor? Was there any action taken against him as a result of this?
Yeah, and this is why I mentioned this particular case, because it wasn't just about the money. This doctor had to be stopped. This practice had to be stopped. These women, massive numbers of women, being damaged in this way, and the effect on their husbands, their loved ones, the entire family, it was just devastating. And you know that if 122 women come forward, Kevin,
something's up.
There were a lot more. Something's up, and also there's a lot more that haven't come forward or did not choose to come forward. So ultimately, the doctor was indefinitely suspended, and that's very hard to do in the state of Illinois. The IDPR, or Illinois Department of Professional Regulation, really does not aggressively pursue doctors in most instances, with one exception. Usually that would be in the instance of sexual misconduct. Then they're a little bit more aggressive because they know that rings a bell, pushes a buzzer with the public. But in this kind of an instance, where they mount a defense that the doctor is just being a great doctor at the forefront of medicine and doing all this
practicing preventive medicine, trying to get ahead of the curve. I can imagine.
He's the greatest doctor that ever lived. Yeah. But in those instances, IDPR is usually much more reticent to act. But in this case, these women were actually so brave and so courageous that when IDPR initially refused to act, they picketed in front of the State of Illinois building.
Was this after the judgment, or after the quick case had concluded?
This is before the case had concluded, but they actually picketed to try and prompt IDPR, to truly conduct, a real investigation into the practices that this doctor was engaging in.
So take that experience then, and tell me how that would inform your judgment on the bench. How would that affect your perspective on cases coming before you?
Yeah, very interesting question. And one of the things I've learned over the years, not just in that case, Kevin, but in so many cases over the 3.5 decades that I've been in practice, is that, as you get to know your client, and in this case, all the clients, which was a challenge in and of itself.
Remembering their names,
sure,
would be the first thing.
But you develop a passion for these people. I mean, a real empathy for these clients. And the only way you can practice law successfully, in my view, is if you have a passion. And in my particular field, you have to have a passion for this seriously injured person, whether it's a medical case or any other type of case. People come into my office, they're hurt. Maybe it's the breadwinner. No income's coming in, and they now have a disability. And they come to you with a hope for justice. You have to make it right. What can you do? can you help me, Mr. Wojcik? Those kinds of things bring tears to my eyes because it really is all on you at that point. They are relying on you to do what's right. And I think I can bring that experience to the bench. I think that empathy is important.
Well, I'm glad you've used two words that I think are important to stress. One is justice, which is not necessarily the same thing as just the law, and empathy, which is something I think anyone who goes to court, and I've spoken with a number of judges in the county, and they all say that no one really expects themselves to be in front of a judge, but you might be. And the one thing you want from that judge is some sense that they understand who you are and what your case is, or what you as a person are presenting. So tell me a little bit about how empathy and justice might differ from the strict letter of the law, which of course has to be observed, but how that might influence some of the gray area around that letter.
As I mentioned, Kevin, with regard to the practice of law, I think you have to have a passion. You have to have a passion for your client. I think the way that translates to the bench is, as a judge, I think you need to hear things and the facts in front of you with compassion. And that's really the difference. So you have to be patient. You have to be able to listen to the facts being presented. If it's a criminal case, you have to try and understand what the backstory is. You have to try and understand this person who's charged maybe with a felony or a serious misdemeanor. How did this person get here? Now, that doesn't make you a social worker from the bench,
right,
but nonetheless, it's important in the reasonable exercise of discretion and in showing empathy for the people before you. You have to look at those kinds of things. If it's a criminal case, is this a young man who's a first-time offender? Has he had any a real adult supervision in his life? Is he being raised by a grandparent or an absentee mom or dad? What is the story? And I think, although some of those things really are the realm of social workers, if a judge who is hearing a case like that does not pay some attention to that and give that consideration in hearing the case, then I think it really does a disservice to the people. So I think everybody's entitled to that as part of the overall concept of justice. Not here's the law, here's the facts, we apply the law to the facts, that's it. I think the law is much more than that.
Actually, I'm encouraged to hear that because as I say, I've spoken with a number of judges on this show and elsewhere. And the theme that comes through to me is that sense that the law doesn't cover everything. The law is certainly a guideline, and there are some places where the law is very clear and you just simply have to follow it. But in many areas, the law is less clear and there is leeway, and there are areas where judgment comes into play. And where, there's now, as you know, there's a move in Congress to reconsider sentencing laws and reconsider, whether we've been too harsh and zero tolerance and those kinds of laws, whether they really are effective or whether they're ineffective. And so on the bench, I'm sure that these are kinds of things that you would wrestle with. Is there an effective way? You've mentioned someone who comes before you who might have a particular backstory. Would a maximum sentence serve this person or serve the public, or would some lesser sentence, do that? I mean, is that the kind of thing that we're talking about here?
Sure, exactly. And I think that's why it's very important that whatever Congress decides to do, judges are allowed to maintain a pretty significant level of discretion. Judges need to have discretion because if Congress, not knowing the person who is going to be in the criminal system, passes laws like the old 3 strikes you're out law. Well, without even hearing the case, they've just set that bar. 1, 2, 3 strikes, literally, you're gone for
life.
Whatever period or life that they designate. Totally takes away the ability of a judge to do what I just described, to try and hear the backstory, have compassion, That's not to say every case is one that requires or demands leniency, by no means, but it does mean that every case should be heard, not only on the merits, but in the context of who it is that's before you, how did they get there, why are they here. In some cases, maybe it's a young man whose life can be set straight by just the right words from the bench at the right time. When a criminal defendant is in front of a judge, that may be the only time in that person's life that they're going to actually sit still and listen to someone. Maybe because they have to, not because they want to, but they will listen. And maybe it's a person who has not listened to advice from a parent or guardian or relative or close friend. And because of that failure to listen and take good advice, they've gone astray. Maybe, just maybe, in some cases, the judge can help set that person back.
It's a
on the
different
right
level,
path.
right? I mean, now there's a difference between your mother or father saying, don't do that, and someone literally up on the bench where you look up and there's the judge on the bench. It's a totally different environment. It's a different emotional, psychological environment to have someone on the bench say, this is wrong, something has to be done here. So I would think that that authority from the bench, speaking to your point, would give that extra weight. And so what I think I hear you saying is that you have to take that weight seriously. As a judge, you take that weight very seriously.
It's absolutely correct, and the correct word is authority. So you are an authority figure. Your words are going to be listened to, and they should be chosen very carefully. And I think those words have to be spoken with compassion, with patience, with understanding, with civility.
And with clarity.
And with clarity. Very important. That's what I would strive to do on the bench. I mean, that would be a level of near perfection, but I think that has to be the goal.
So we've only got about a minute left. So is there something that you would like to sum up about your experience? And I'll give you a little quick context. A lot of people who come before me have been prosecutors. They've been public defenders, as you mentioned. And they always position that as being a real positive. I know both sides. I've been a prosecutor, I've been a defender. And you've really always been on the civil side. So why do you think that gives you an edge in about 60 seconds?
I think the experience that I've had makes me well aware of the practical problems that people have, because I'm dealing with people on a person-to-person basis, on a grassroots type basis. And so, as I've mentioned, when people come in and they have serious problems, and I'm called upon to make them right, in the length of time I've been doing that, I think that does give me a very unique perspective. So we don't do cookie cutter things. We're not a volume office. Sometimes in the state's attorney's office, maybe they're handling 200 cases on a particular court call in a morning. We don't do that. So we've gotten to know people. I think we've become good judges of character.
Well, on that note, we're out of time. William Wojcik, thank you so much for being here, and you're on the ballot for Cook County Circuit Court Judge.
Democrat ballot, punch 226.
226, okay. So thank you for joining us once again on Public Perspective. Hopefully you're much more informed about the judiciary now, and you'll vote on March 15th. So till next time, I'm Kevin McDermott. Actually, I'm Kevin McDermott all the time. We'll see you next time on Public Perspective. You can catch us every Saturday night at 8 on Comcast Channel 19, and find us on the web at publicperspective.tv. Till next time, thank you and good night. sort of talking generally, the story itself